Although reservations were contemplated for backward classes, reservation along the lines of caste has dominated the Indian political scape.
ये जो 50% का लिमिट लगा रखा है, इस लिमिट को हम हटा देंगे, परे कर देंगे।
More than 75 years after independence, reservations at local, state and central level has continued to be relevant and necessary in India. The Supreme Court has time and again reiterated that before enacting laws to implement reservations, the state must provide evidence of compelling reasons like the backwardness of the class, inadequacy of the representation and the need to maintain administrative efficiency. Has the idea of reservation truly served its purpose and objective? How has the idea expanded in the political landscape? Can reservations be solely based on economic criteria? Is there a need for reservation in India? The Constitution of India specifically indicates that the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex or place of birth. The Constitution itself permits the state to make special provisions for the advancement of any socially or economically backward classes of citizens or for the scheduled castes and scheduled tribes. The Constitution also denotes that the state can make provision for reservation for appointments or posts in favor of the backward classes of citizens or the scheduled castes and scheduled tribes. Although reservations were contemplated for backward classes, reservation along the lines of caste has dominated the Indian political scape. Caste-based reservations has defined the political grammar in India. Reservations for the historically marginalized groups is part of the Indian Constitution. Dr. Bhimrao Ambedkar, one of the architects of the Indian Constitution, argued that true equality can only be created in a society by the affirmative action of creating reservations. More than 75 years after independence, reservations at local, state and central level has continued to be relevant and necessary in India. Has the idea of reservation truly served its purpose and objective? How has the idea expanded in the political landscape? One of the key objectives of the Constitution of India is to guarantee all citizens equality of status and of opportunity, whilst at the same time fostering a sense of fraternity. To address the vast inequalities, historical marginalization and denial of basic rights to the scheduled caste, the scheduled tribe communities and for other backward classes, the framers of the Constitution mandated positive state action and allowed for reservations in educational admissions and in governmental appointments. Reservation provides a special support to the disadvantaged so that they can compete with the more privileged. The Supreme Court, in the case of Air India versus Nargis Mirza, emphasized that inequality in any form should not be tolerated and true equality equals to complete justice. Reservation is seen as a tool to achieve that complete justice. In the landmark case of Indra Sawhney versus Union of India, the Supreme Court noted that Article 16(4), which allows for reservations in public employment, complements the equality principle enshrined in Article 14, and both provisions must be interpreted harmoniously to achieve their common goal of equality. The primary and at times Puritan criticism of reservation is that it undermines the concept of merit, leaving talented individuals behind. Critics argue that reservation allows individuals from less qualified backgrounds to bypass merit-based selection. However, this narrow view of merit tends to overlook the caste privileges enjoyed by the upper caste individuals over centuries, which has ingrained inequalities in the social fabric of our country. In a leading case, the Supreme Court emphasized that merit should be understood in a broader social context. The court ruled that merit should be seen as a tool for promoting social good like equality, and that reservations do not contradict merit but rather advance social justice by addressing the historical disadvantages. The Supreme Court declared that merit cannot be measured solely by competitive exam scores which fail to account for the social, economic and cultural privileges and advantages that have been received by particular groups. Qualities like commitment to public service and resilience are also important indicators of merit. State level reservations for locals or local communities has now become a common scenario in most states across the country, especially the economically richer states which have witnessed migration from the neighboring states have had a tantamount tryst with the idea of reservations. Whether it is the recent debate around the Maratha reservation or the idea of a Kannadiga, Tamil or Jat reservation, often these issues have found place in poll manifestos swinging election results. Though the judgment in Indra Sawhney has placed a 50% ceiling on the quantum of reservation, that has not deterred state governments from playing to the gallery, and the courts are often called to test the constitutionality of such decisions of various state governments. It all started with the case of the state of Madras of Champakam Dorerajam as early as 1951. The then Madras government had reserved seats in medical and engineering colleges, which was challenged as unconstitutional. The government of the day defended its decision by citing Article 46 of the Constitution, which eludes the state to work towards promoting the welfare of weaker sections. However, the Supreme Court then struck down the reservation as violative of Article 15(1)'s guarantee of equality, holding that directive principles cannot override fundamental rights. Now, this led to the first amendment to the Constitution, which added Article 15, subclause 4, allowing the state to make special provisions for the socially and educationally backward classes as well as the scheduled castes and scheduled tribes. In another case, that is of Balaji, the Supreme Court deemed that government's 68% reservation for medical, engineering and technical colleges were unconstitutional, citing it as excessive and unreasonable. The court established that a ceiling limit of 50% for reservations in educational institutions and public employment was necessary to ensure that merit was not unduly compromised. In various subsequent judgments, the Supreme Court applied the 50% reservation limit to positions carried forward to the following year, declaring unconstitutional a rule that allowed vacancies to increase reservations beyond 64% in the subsequent year. Again, in Indra Sawhney, the Supreme Court reaffirmed the 50% reservation ceiling and invalidated the carry forward rule if such rule breached this limit. Following this, the Constitution was again amended, inserting Article 16, Clause 4A to permit reservations in promotions for the scheduled caste and scheduled tribe employees, and Article 16, 4B to allow unfulfilled reservation vacancies to be carried forward without being counted towards the 50% ceiling of the year's vacancies. The Mandal Commission, which proposed reservations to OBCs or the other backward classes in India, opened a new chapter in the Indian legal and political history. Apart from scheduled castes and scheduled tribes, now a vast number of castes could obtain reservation under the banner of other backward classes. In the landmark decision again of Indra Sawhney, the Supreme Court upheld reservations for other backward classes but emphasized the need to exclude the creamy layer. The court stated that such individuals are as advanced as members of the forward classes and should not benefit from the reservations, while the exclusion of the creamy layer shouldn't be based solely on economic factors. The court noted that when economic advancement leads to inevitable social progress, income can be considered as a reflection of social status. The Supreme Court has time and again reiterated that before enacting laws to implement reservations, the state must provide evidence of compelling reasons like the backwardness of the class, inadequacy of the representation, and the need to maintain administrative efficiency. Additionally, the state must gather quantifiable data showing backwardness and inadequate representation of that class in public employment, ensuring compliance with Article 335 of the Constitution. Now the question arises, can reservations be solely based on economic criteria? Now this question led to a crucial chapter in history of reservations in India, and that was created when the Parliament approved reservations based on economic criteria. Now, in the Indra Sawhney judgment, the Supreme Court held that backwardness under Article 16, Clause 4 refers primarily to social factors and not economic or educational ones. The court further ruled that economic criteria alone cannot define backwardness under Article 16(4) and rejected an official memorandum that provided a 10% reservation for the economically backward sections, holding that classification based solely on income or property was inconsistent with equal opportunity under Article 16(1). However, the 103rd Constitutional Amendment introduced a 10% reservation for the economically weaker sections or EWS, which applied to those not already covered by reservations for scheduled caste, scheduled tribe or OBC groups. The amendment raised the total reservation percentage to 60% and classified EWS as individuals from the general category with an annual income of below 8 lakhs. Economic criteria based reservations do not violate the Constitution's fundamental principles and align with the objective of supporting disadvantaged groups even beyond those who are socially and educationally backward. The Supreme Court ruled that excluding scheduled caste, scheduled tribe and OBC categories from EWS reservations is a balanced measure that aligns with the principle of non-discrimination and compensatory discrimination without violating the equality code enshrined in the Constitution. EWS reservations does not cause any damage to the basic structure of the Constitution. The Supreme Court has clearly reiterated on multiple occasions that the provisions pertaining to reservations, that is Article 16(4), 16 and 4A, do not grant fundamental rights or impose constitutional duties. Instead, they serve as an enabling provision, allowing the state the discretion to consider implementing reservations. The Supreme Court also proposed the idea of a time limit on reservations, suggesting that such measures could help move towards an egalitarian, casteless society, and the court cautioned against the potential negative impact of reservations by creating new divisions within society. The court highlighted the need for a balanced affirmative action that does not exclude those who face high competition barriers but do not fall under reserved categories. This balance is essential to achieving the constitutional goals of equality and social justice. The Supreme Court has repeatedly underscored that backward classes should not remain perpetually backward. Reservations are intended as a transient measure to address backwardness. The distinction between backward and non-backward classes must eventually disappear. It likened reservations to first aid, stressing that they cannot provide permanent solution to the deeply rooted issue of backwardness in the country. Indian reservation system, initially designed to promote social equity, now requires further impetus and significant reform to foster true equality. And this must be done thoughtfully, balancing present realities with the need to eradicate past imbalances.